Good morning. Happy Sunday to everybody. And thank you for joining us on this Sunday show. I know it's been a little while and there's been some trouble getting Salman back on the channel just because he's so busy and running around. But after a lot of hard work, we got him back for today because we have to talk about more what's going on with Turtleboys witness intimidation charges. You guys know I did some research on it. I did some videos about it, and I'm still digging more into the case, looking into some more research on the case. And, there's some First Amendment issues, which, of course, Salman's very familiar with. There's also some other issues that a lot of people are talking about, and it would be helpful to get someone who's an experienced practitioner, definitely someone in federal court, to talk about some of the issues that we keep seeing coming up specifically with this case. So without any further ado, because we don't have so much time with Salman, but he is generous enough to give us at least hopefully an hour of his time, we are going to bring up national trial lawyer Salman Rander. Welcome back to the show. Thank you very much for your time today.
Great to be here. Long time no see. Hope you're well.
Yeah, and we know that next week we are probably we're not going to be able to do the show also. So I hate to be the bearer of bad news, but we're going to have to go on a little break because next week we're both going to be tied up on Sunday.
That's correct.
Yeah, so maybe the week after, or maybe you have any summer plans with the family, but we'll have to take it day by day or week by week, huh?
We'll make time. I love being on your show, so we'll figure it out.
Okay. All right. Well, then let's jump right into it. Let's talk. I know I sent you a few documents, but one of the most interesting I found interesting was the letter by Mark Betterow. So I sent you that letter. So give us kind of your take on, let's first take the discovery issue. Just to set it up for you, they were in open court. I forgot exactly what day it was, but a couple weeks ago they were in court, and they're waiting on this discovery. They're waiting on pages and pages of discovery. They keep asking for discovery, and finally, in court, the prosecutor says to the judge, "We are going to be handing over 5,000 documents of discovery today." Well, they get the discovery. The defense gets the discovery, and it turns out that 4,000 pages of the 5,000 are blank, and still a couple hundred more are redacted. So put yourself in that situation and tell me what your thoughts and what you think you would be doing to take care of that situation.
Well, okay, so just from 20,000 feet, there's a few things that kind of jump out at me. First and foremost, anytime you send discovery to the other side and there's redactions, any form of redactions at all, it's usually supposed to come with what's called a privilege log, which is where you explain why those things are being redacted and the basis or bases for such redactions, whether it's attorney-client privilege, work product, some other privilege perhaps, whatever it might be that protects that piece of information from being disclosed, you would have to explain the basis for it. Obviously, you don't get into detail. You don't say exactly what's in it, but you definitely have to explain why it is that it's not being disclosed. And I don't see that that was done. It's certainly not referenced in the letter. That's problem number one that just jumps out at me right off the bat. Problem number two is obviously the most glaring thing, and that's the 4,000 blank pages. Anytime you send over a PDF in any sort of discovery that contains blank pages after you told your opposition and the court that you're going to send over X number of pages and 80% of them are completely blank, you've got a real problem on your hands explaining not only to the other side, but eventually to the court why it is that you, A, represented that you were going to send 5,000 pages when 4,000 were blank, and B, why 4,000 of them were blank. There could be explanations for this, but you really got to dig deep and be creative to try to think of an explanation. The best I can come up with is the lead prosecutor saw a PDF, saw that there was a 5,000 page PDF, didn't open it yet, or maybe opened it but only saw a page or two as he was walking into court, and then told the court and told his opposition, there's a 5,000 page PDF that I have to send you. Now, why he would not have seen that prior to going into court, or at least look through it and know what's in it, is beyond me. But when you're going to send over a 5,000 page PDF and 4,000 of them are blank, you better expect to be either show caused or sanctioned or possibly both, because that's going to be something that's difficult to explain. Those are pretty much the things that kind of jump out at me just from 20,000 feet. We can get into the nitty gritty if you want, but that's kind of what jumped out at me.
Do you think that this could rise to the level of a dismissal?
That's a very good question, and it depends. I don't think right off the bat that it's going to be enough for a dismissal, because another question that's always going to be asked is what relevance and what teeth did this discovery actually have? This is a case where I think the majority of the evidence comes from Mr. Carney himself. The videos, the voicemails, the messages, the rallies, things like that. And I'm sure we'll get into that at some point during this hour. But exactly how relevant this information is with what's referenced in this letter with Catherine Peter is, I think, secondary to the major discovery violations taking place. If there's something minor that you're supposed to turn over and you go to the court and I'm not saying this is what happened here, but if you go to the court and lie about it and misrepresent it and say false things to the court, that could be the kind of thing that gets the case thrown out, potentially. But based on what I see here right now, I'd be very surprised if this forms a basis in and of itself to get dismissed. I think possibly a show cause and or sanctions might be in order, though.
Yeah, well, I think some of the information that they're looking for, some of the emails and correspondence and communications between Catherine Peter and Cosgrove, the prosecutor, or the Commonwealth, whoever else she's been communicating with. So, I mean, I didn't see the actual discovery request, so I don't know exactly what's included in it. But I know I don't think it's just the videos and things like that. I'm sure there's a lot of other materials that they're waiting for. Now, there's also this other issue where they have certain communications, at least we are led to believe, of this complaining witness or this helpful witness, Catherine Peter. That's at least what the papers identify as a helpful witness, and everything's impounded. They're trying to unimpound all of these communications to let the public know what's the type of communications that were going on with this witness and the Commonwealth. And maybe you've seen from the letter also that it seems like there is this witness, Catherine Peter, who's had some sort of troubled history with Turtleboy. They used to work together, and then they had a falling out, and it seems like she just wants to nail him one way or the other. And she is their star witness. She's the one that's providing them all this information. That's what the letter, anyway, suggests. What is your take about when the Commonwealth or the prosecution puts all of their eggs, so to say, in one basket, or mostly in one basket, when they have this one cooperating civilian individual who's feeding them all this information, who is a enemy of this person who they are prosecuting?
Okay, so before we dive into that, you have to realize, and I think a lot of people probably do know this, but it's worth repeating, that very often in a criminal proceeding, you're going to have witnesses testify against each other who hate each other, people who sometimes work together, sometimes they had a falling out. You often see co-defendants testify against each other in exchange for leniency. You almost always see this in murder cases, where there's multiple people indicted or charged for murder, and then they end up testifying against each other in exchange for a lighter sentence. That happens all the time. I don't think I've ever had a murder case with multiple people charged where offers weren't made to everybody. Or they usually start from the lower people and kind of get to the higher people on the totem pole, so to speak. But that's quite common. So the fact that somebody has a checkered past or a reason to lie is not necessarily going to sink them as a witness. However, when you've got a situation like this where, as is made out in the letter, they're submitting potentially completely forged complaints. And I don't know if this is something you want to get into or not, but
yeah, well, let's jump into that right now.
Yeah. So this complaint that was filed, and I know you pulled it up, you sent it over to me, with the 13 filing code, which means that it was filed in 2013, and then the caption was completely changed, and it was written as right there. So we've got it's a 13 CV. So just so everybody understands what this is, 13 is the year. CV means that it's civil, and then that's the case number 12028. And this is a completely different case than the one that's actually filed under that case number. It's dated March 24, 2020, smack in the middle of COVID, apparently. And And then it's got this wrong date on it, and it's signed by Catherine Peter. When you actually pull that case up in Pacer, you actually see something else. And yeah, you're showing it right now. You see this, and you'll see just right off the bat, does everybody see this line across the top over here where it says case 1:13-CV? Yeah, right there that you're highlighting. That is on every single federal filing in any federal court in the country that I've ever seen. Every single federal filing has that. And that right there makes it very clear how you can identify a document in any court just by this number. Document 1, page 1 of 11. There is only one document in the history of this planet that has that marking across it. And that's this one single page right here. So for Catherine Peter to apparently or allegedly file this in a different case right over here that you're showing now, without that stamp across the top and with this case number and with this caption, I think this could create a real problem for her and for her credibility. If her credibility is needed, then it's a real problem. Now, if all she did was produce video and there's no question about the authenticity of the video, then her credibility doesn't really come into play and her motives don't really come into play because it's largely irrelevant. But anytime you have a witness like this and you have the basis of evidence coming from somebody with this kind of background and with this kind of clear documented problem, it's certainly something that any defense attorney is going to want to jump into and demand. And that's why Mr. Betterow did that. He did an excellent job. It's a very, very well-written letter, very intelligently written letter. There's a number of reasons why. We'll
get to that in a minute.
A problem for the prosecutor.
Yeah, I mean, so in terms of the prosecution using a witness where they see this stuff going on, these type of shenanigans, where this is potentially some real serious issues. I mean, as you saw in the letter, and let me see if I can pull this part of the letter up. Here, can you give a little bit more, everybody there understanding everything about this statement in the letter? So, it's too much.
Whatever you're doing, you're not showing right now. It's not understood.
Oh, okay. Yeah, let me pull it up. So here's the letter. Ms. Peters' complaint was in fact a forgery and a lawsuit fabricated out of whole cloth. She located an authentic copyright claim filed in the District of Massachusetts in 2013 and then brazenly changed the caption and other information in the authentic document so that her forged document appeared to be an actual civil complaint she filed against Mr. Carney. Then he says this next sentence, which I let everybody know he's hinting at a very serious charge here. She signed the falsified complaint, represented it to be true and accurate civil complaint, and transmitted it in interstate commerce, which obviously you and I both know has some significant meaning, in furtherance of her fraudulent and criminal scheme to intentionally mislead YouTube into ruling in her favor, which based upon her forged documents, they did rule in her favor. So this is something that she submitted to YouTube in furtherance of her copyright complaint. Again, this is all based on the letter. It's not my opinion. This is just what the letter says. And because of this fraudulent complaint, apparently YouTube didn't turn this over to their lawyers, because if the lawyers would have seen it, they would have realized right away it's a forgery. And now he's saying something about this interstate commerce. So what's your understanding of what he's trying to signify here? Maybe hint at what Ms. Peter may have done here.
Could be a number of things. First and foremost, I mean, this could not only be a state felony, this could potentially be a federal felony as well because of the interstate commerce aspect of it. Anytime you use the wire, an interstate wire of some sort, whether it's email or filing or whatever it might be, if you use the mail, it's mail fraud. If you use the wire, it's wire fraud. That could be a felony, a federal felony, and that could be a real problem for her. It could also be a state felony, I'm sure, and it just depends which one, whether it's forgery or fraud or some sort of misrepresentation. Committing fraud like this, as is outlined in this letter, again, if it's accurate, is going to be a real problem for her because she could face not only civil but criminal liability. And there could be a number of reasons that you put this in writing and kind of send it to the court. I've had instances where I've done similar things where it's very clear that there's a star witness of the prosecutor who's going to lie or has been proven to lie. And if he or she gets called up as a witness again, there's little question that he or she is going to commit perjury again. So what I'll do is I'll file a motion with the court or send a letter to the prosecutor and kind of CC the law clerk of the judge just to let them know what's going on, laying out exactly how I know for a fact that this person is about to commit perjury and that this person really should be afforded counsel. and given some sort of lawyer to represent him or her, to advise this person on whether or not they should continue to testify or whether they should assert their Fifth Amendment rights. Because here's the thing, if I know somebody's going to commit perjury and it's my job to bring that out because it helps my client, I'm not going to tell them, hey, you should have a lawyer and you should figure out whether or not you need to plead the Fifth, because that could be witness intimidation on my part. And I've actually seen this happen. I saw this happen one time in a courtroom where there was somebody who went over to one of the witnesses he was about to cross-examine and basically told her that she should plead the Fifth. And I was watching this. I was a very young lawyer at the time, and I was shocked. And I went back and I asked one of my mentors afterwards about it, and he said, yeah, it's a real problem. Now, thankfully, that witness didn't end up getting called. So, crisis averted. But if a witness is going to get called and you think that they're going to commit perjury, you can't go to them and say, you should really think about pleading the Fifth. What you can do is you can go to the court and say, hey, judge, this person might need a lawyer. You need to appoint this person a lawyer, and here's why. And that could be a very strong, powerful move, because now you're putting the prosecutor on the defense. And the prosecutor may have to be in a position now where they have to explain why they called a witness who committed perjury and why they may call a witness again who might commit perjury.
Right. And what we're seeing also, I think what he's trying to show in this letter is that this is who their star witness is. And this should be problematic for the prosecution to continue a prosecution where this is their star witness who's very obviously committing these type of forgeries and fraud. Here's a question which Margaret Ferenz asked: can the prosecutor send the defense the corrected version of the PDF now before the next court date? And the answer to that is, of course. That's the point of the letter.
There's an obligation. Yeah. Not only from the court, because it's pretty much what was ordered in the court and what was told to the court was going to happen, but also under Brady. Brady versus Maryland makes it very clear that things like this have to be produced to the defense.
Right. So
yeah, if they have a corrected PDF, they're going to have to send it over. And if not, if this is what they have, 4,000 blank pages, there's going to have to be a interesting court hearing in which this is all discussed and explained.
Yeah, and that's coming up. I think it's the next hearing is, what is it, August 13th, I think it is. So so then I guess that kind of leads us into the next part about, so why, and people try to understand this also. I explained it one time on my channel, but let's hear your take about it. You don't always see letters. You see motions being filed. You see briefs. Sometimes you see pretrial motions. You see all different types of things that are being filed. Sometimes a pretrial memo or, something like that. Here you have a letter. So I guess the first question people want to know, do real lawyers write letters? Number one. And number two, what's the strategy here? And what's the purpose? And do you think this was a good move? Should he have filed a motion immediately for sanctions? What do you think about this whole approach?
This is a perfect approach. This is what an experienced litigator like Mr. Betterow would do. And here's why. If you jump and you file a motion, they're going to file a response which explains it away, and then you look like a jerk for jumping to the worst conclusion possible and making it sound horrible and making all kinds of nasty allegations against the prosecutor and the Commonwealth, and how dare you. Okay, so that's why what you do is you put this in a letter. You make it very clear. You make it very detailed, exactly like Mr. Betterow did in this case. You explain every single issue that you have with the discovery, and you give them an opportunity to respond. Now, you also have to be able to, at some point in time, you don't know if they're going to deny getting that letter or deny ever receiving that letter or saying that they just got it a day ago, even if they got it a month ago. So the way that you prevent that is by either CCing the court clerk or filing it with the court or including other people so that it absolutely cannot be denied. There is right now absolutely no question in the world that this letter was written on July 12th, 2025 and sent to the prosecutor, period. That was done. Now, when they come to court on August 13th, this letter can now be discussed. This discovery can now be discussed. If not for this letter, then when they get to court on August 13th, it's very possible that Mr. Betterow would get up and say, what about these 4,000 missing pages? And the prosecutor would say, what are you talking about? Oh, I sent you a letter. I don't remember seeing that letter. I'm not sure. Maybe it bounced back or I didn't get it or something along those lines. You never know. But rather than casting stones unnecessarily, CC somebody, file it with the court. Whether it gets struck or not is irrelevant. Because right now, without question, that letter exists and it's very detailed. So now the prosecutor is going to have to put a little bit of defense. Very, very intelligently written letter by Mr. Betterow, if I may say so myself.
So let's pull up this, because this is what all the antis are getting all excited about. They get really excited about this part. I tried to explain it on my channel once, but maybe you can explain your take on this. So this is on the docket, and the docket says, general correspondence regarding July 12th, redacted and unredacted letter from Attorney Betterow to Special Assistant District Attorney Cosgrove received, period. Order. The above letter is not in the form of a motion for discovery pursuant to Rule 14 of the Massachusetts Rules of Criminal Procedure. It is order returned to the counsel for the defendant. It may be refiled in proper form, and Doolin is the name of the judge. So, all the haters get all excited about this. What's your take on that?
Okay, so right off the bat, again, I probably would have done the same thing. If there's a letter like this which details these kinds of problems, you don't want to file it as a motion right off the bat. You want to send it as a letter, and you want to somehow include the court, whether it's a CC or something else. Sometimes what I'll do is I'll send an email to the defense attorney. I'll CC the judge, and I'll say, Your Honor, here's the issue that's going on right now. I don't see us being able to resolve this, so I think we should have a court date. However, should the opposing counsel get back to me and we resolve this, I'll notify you. And then that way you kind of let them know right off the bat, we've got this issue. We're going to have to deal with it at some point. And it's very clear the day that you pointed it out and what the issues are. The fact that it's struck by the court, again, I think different judges will handle this differently. Some judges will accept it as a miscellaneous filing or as an exhibit of some sort, and some judges may strike it. Either way, it doesn't matter, because the fact of the matter is this letter now exists without question and goes through very specific issues in great detail that will be discussed now on August 13th. Now, if Mr. Betterow wants, he could file this as a motion to compel, motion for sanctions. There's a number of different types of motions he can file this as, and then attach this letter as an exhibit. But just filing the letter in and of itself as a letter, yes, it's not a proper motion form. But again, I think some judges would allow it to stay on the docket and some may not. But I think that's beside the point. And I still think that the way that Mr. Betterow did this, I think, is quite brilliant.
Yeah. And as I said, I think... And as I said, I think that letter is going to be eventually an exhibit to a motion to compel or for sanctions, to say, hey, we did send our request to the prosecution, let them know what's going on. Look at Exhibit 1, and that will be the letter. So, whether it's going to be formally filed is most likely going to happen, I think, anyway. But here it's just a way to cross all your T's, dot all your I's, make sure the court, if they want to accept it, they could accept it. If not, he CC'd them anyway. It's just doing everything 100% by the book. And yeah, hats off to Mr. Betterow. He knows what he's doing. So, Salman, let's kind of get into now some of the details of the case. And, we're going to get into the details. We're going to talk about it. This is part of the reason, actually, I've had communications with Turtleboy, and we were discussing maybe coming onto my show to have an interview. And part of the reason why I took a step back from that is that, these are very serious charges, witness intimidation charges. And like we saw with the Karen Reed case, where they can just clip certain portions of interviews and use it against him. I don't want to be responsible for asking some of the tough questions, some of the detail-oriented questions, some of the intent questions, which we're going to talk about. And I don't want them to be able to use that against him. So that's kind of why I took a step back. So maybe we'll revisit that. But you and I can talk about it. They can't use our clips, for anything. So let's first pull up the road rally statute. And I know that you're the civil rights guy. So first, as a starting point, let's talk about whether you feel that this statute in the first place is constitutional. Does it go right against the First Amendment? So here's what it says. This is, as you see from the top, this is what they call the picketing court judge, juror, witness, or court officer. Whoever with the intent of interfering with, obstructing, or impeding the administration of justice, and of course intent is a big word there, or with the intent of influencing any judge, juror, witness, or court officer in the discharge of his duty, pickets or parades in or near a building housing a court of the Commonwealth, or in or near a building or residence occupied or used by such judge, juror, witness, or court officer shall be punished by a fine of not more than $5,000 or by imprisonment for not more than 1 year or both. So that is one of the charges that he's facing now, this road rally. So just on its face, before we even get into the details of the road rally, is there something unconstitutional that you feel about this statute?
On its face, let me read it a little more carefully. On its face, I don't see anything problematic about this. This would be a content-based restriction of the First Amendment. There's different types of restrictions. We talked about time, place, and manner in a different video. We talked about content also in that video a little bit. This would be specifically a content-based, which basically means you're not allowed to say the following things. You're not allowed to do the following things. Not allowed to say the following words or act in a very specific way. It's not time, place, and manner. It's not that you're not allowed to do this late at night, or you're not allowed to put it on a billboard, or you're not allowed to blast it out and violate noise ordinances. That would be a time, place, and manner restriction. This is actually content. You're restricting content. Restricting content is very tricky for the federal government to do, or for any government to do. And the First Amendment requires what's called a strict scrutiny test. Strict scrutiny test means that there's a compelling government interest, and it has to be narrowly tailored specific to this specific conduct and these results that you need. But it has to be narrowly tailored. It has to be the least restrictive means possible in order to pass constitutional muster. Looking at that statute on its face, it's not saying you're not allowed to talk to witnesses. It's not saying that you're not allowed to be anywhere near them. It says very clearly that you're not allowed to have the specific intent of interfering, obstructing, or impeding the administration of justice. Administering justice is obviously a compelling government interest, and precluding specific conduct, such as specific intent to interfere, obstruct, or impede the administration of justice, is definitely something that would fall within the narrowly tailored. So it's got to be narrowly tailored. It's got to be least restrictive, and I don't see a problem with what's written here based on the First Amendment test that would be utilized to determine constitutionality of the statute.
Okay, so
on its face, I'm not talking about.
Yeah, we're just talking. Yeah,
as applied is a completely different story.
Yeah, yeah. So let's move on to actually what the road rally looked like in this case. Okay, so this is I'm taking this from the opinion on the order to dismiss, where the judge kind of goes through what happened. So some of it's going to be based on grand jury testimony, which obviously we don't have access to, and you kind of just have to take their word for it. But and he's allowed to do that at this stage because this is a motion to dismiss for number one, based on the unconstitutionality of the statute, but also number two is that there was insufficient evidence presented at the grand jury to indict him in the first place, even for probable cause. So take a look at, we'll go through some of this, what happened at the road rally. So talking about Carney, we'll talk about Dr. Turtleboy, trying to use his preferred pronouns, of course. So we'll try to insert Dr. Turtleboy. At around noon on July 22nd, 2023, Dr. Turtleboy and his followers met in a supermarket parking lot in Norwood, Massachusetts. Carney recorded the rally as he and his followers drove from one witness's residence to the next, accusing the various witnesses of being involved in the murder of O'Keefe. So here we got the witnesses. He's going specifically to the witness's residence. So that part of the statute we do find. Carney and his followers stopped outside of Brian Albert's residence in Norwood, Massachusetts. Brian is a retired Boston police officer and a witness in the Reed case. While at Brian Albert's residence, Carney used a bullhorn to call Brian Albert a murderer. At some point, Carney or his followers noticed Brian Albert had a camera outside his home and began to tell Brian that he better tell the truth and that he's a liar. Brian Albert testified that on that date, he believed Carney and his followers were attempting to intimidate him and his family. So now that's Brian Albert's own belief. Is that going to make a difference whether that's his belief or not? So let's talk about his actions in terms of Brian Albert. So what do you think in terms of this road rally and getting in front of Brian Albert's house and calling him a murderer and that he should tell the truth? Is that witness intimidation? What do you think one way or the other?
Well, hang on. Are we talking about the felony witness intimidation, or are we talking about the misdemeanor road rally?
Well, let's talk about the road rally.
Okay. So as far as road rally goes, the question is this done with the specific intent of obstructing or impeding the administration of justice. I can tell you right now that a very interesting defense would be, I wasn't trying to impede or interfere with justice at all. I wanted him to be truthful. I wanted him to tell the truth, which he was not going to do, which we all know he was not going to do. And if that's the defense, I could see a jury buying that. Because look, the bottom line is you're not guilty of a crime unless the jury says you're guilty of a crime. And he's going to be allowed under the due process clause to put forward a defense. So if that defense is, at no point in time did I intentionally have the specific intent of impeding or interfering with the administration of justice, because committing perjury and convicting an innocent woman is not the administration of justice. All I was doing was telling him to tell the truth. I wasn't trying to interfere with his truthful testimony at all. Because again, we have to, and this is where things are going to get really hairy for the prosecutor. And I got to be straight with you. I think the prosecutor would be crazy to try this case. Okay, this is a case that the prosecutor is going to want to resolve. Frankly, I think the defense is going to want to resolve this too. And if I had $1 to bet, I would bet that this case probably will get resolved pretty quickly. Or I shouldn't say that, but I think pretty soon it'll be resolved in some sort of plea bargain resolution, something or another. Just because there's too much on both sides here that could really go wrong. Specifically with whether there's an intent to impede justice, that's necessarily going to bring up the Karen Reed case. And I'd hate to relitigate that, and I'm sure the prosecutors would also hate to relitigate that. That said, I'm sure Mr. Carney would love to relitigate that and show the jury exactly why he said everything that he said. Yes, he was a murderer. Let me show you why he was a murderer. Because there's absolutely no question at all that Karen Reed did not hit John O'Keefe, period. And if that's the case, somebody murdered him. Who was it? Who else could it have been? You have to remember, looking back at the trial, and I know I'm kind of going off on a tangent here, but let's just remember, I think it's important for background. There were two facts that were pretty much established at the Karen Reed trial that, without question, prove her innocence. Fact number one, she did not hit John O'Keefe with her car, period. That was established. It was established so strongly in the defense's case that the prosecutor didn't even call any rebuttal witnesses on that fact. And fact number two, those bite marks were bite marks. Those two facts, which I think are established beyond any question, are impossible for Karen Reed to have been the killer, period. That necessarily means somebody else did kill him. And based on the prosecutor's own theory, he was murdered. So who murdered him? Well, Mr. Carney is going to have the right to get up at trial and explain why he said what he said. And telling somebody he's a murderer when in fact he's a murderer is protected speech. And no, I wasn't trying to intimidate anybody and trying to impede justice. I wanted justice to happen. I wanted them to come to court and tell the truth. And they didn't. I'm saying what his defense would be, I think. So I think this would be a very, very strong defense. And that's why at the same time, there's a lot for Mr. Carney to potentially lose here. And that's why I think this case has resolution written all over it. It's not like the Karen Reed case where she had to go to trial because she was facing life in prison. A case like this, I think there's a very strong likelihood the prosecutor is going to come with a deal which is too good to turn down, whatever that deal might be, and resolve it. But again, I'm kind of ahead of myself.
Well, Salman, what do you think about this? Because, the prosecution, the Commonwealth, they're kind of walking out as the losers in the Karen Reed case, very obviously. They wasted all this money and resources into trying to convict this innocent woman. Right. And this may be their little carrot. Let's at least get Turtleboy, and then at least we don't have the same mud on our face anymore. At least we got someone. Someone got to prison. So maybe that would be the reason why they don't want to resolve this, and they say, look, okay, maybe we messed up on Karen Reed, but at least we got Turtleboy. What do you think about that?
If that's what's motivating the prosecution in this case, then shame on them. That's incredibly shameful conduct for a prosecutor. When prosecutors are motivated by something other than the pursuit of justice, whether it's ego, whether it's regaining their standing in the community, if they think that this would actually help them do that, I think it's doing the exact opposite. But if that's what's motivating the prosecution in any case, then I think that's very improper. And that's really not what prosecutors are supposed to do. In fact, there's specific rules of ethics that apply to prosecutors that require them to make sure that at all times they are pursuing justice and nothing else is motivating them. So if the thing that's motivating them, and look, this is going to require some reflection on their part. I don't know if they're capable of doing that, frankly, at this point. But if they're capable of actually being intellectually honest with themselves and looking at this case and asking themselves, what is motivating us to litigate this case right now? Why are we going so hard against Turtleboy? If you look at the charging document, it reads like somebody who has a beef with him, not like a prosecutor who is pursuing justice, in my opinion. It reads a lot. I know you don't like getting political. It reads a lot like the Trump indictments. Okay, it was very clearly motivated by somebody who hates him very, very much. Whether it's right or wrong, I'm not getting into. But when you read a document like this, and it goes through all the history, and they spent all this time, and it's such a lengthy charging document, and they charge him with all these charges, it's very clear, in my opinion, that they are being motivated, at least in part, by something other than the pursuit of justice, whether it's ego or getting a pound of flesh or whatever it might be. And I think that's a very dangerous thing for the prosecutor to do in any case.
Yeah, I got you. So let's talk about the tell the truth, and as it relates to the witness intimidation statute. Okay, so let me just pull that up for a moment, so just we can understand about that. The witness, this is the witness intimidation statute 13B, and they define harass here to engage in an act directed at a specific person or group of persons that seriously alarms or annoys such person or group of persons and would cause a reasonable person or group of persons to suffer substantial emotional distress. Okay, so that's what harass means. And then continuing on, that's just the definitions. And then here's where it's actually saying what witness intimidation is. Whoever willfully, either directly or indirectly, threatens, attempts, or causes physical, emotional, or economic injury or property damage to convey a gift, etc., or misleads, intimidates, or harass another person who is a witness or potential witness, person who is or aware of information. So here again, we have the willfully, we have the misleads, intimidates, or harass another person, and then finally, the last part of the statute is with the intent to or with reckless disregard for the fact that it may impede, obstruct, delay, prevent, or otherwise interfere with a criminal investigation at any stage, yada, 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 yada. So harass, which is directed at a specific witness, which I think we can kind of agree here was done. It was directed at Brian Albert, Jennifer McCabe, Chris Albert, Colin Albert, right? So that part, you can make an argument that the harass part is there. But what about this part? With the intent to or with reckless disregard that it may impede, obstruct, delay. Now, I know your first argument was, well, this is not Turtleboy trying to impede or obstruct or delay. This is him actually wanting the administration of justice to actually occur. But let's take a step away from that argument for a moment and talk about this. When you tell somebody, tell the truth, can that mean that I'm trying to intimidate them to change their testimony or not testify?
That's a good question. I think it could. I think this is the kind of case that if both sides really insist, or if either side really insists, this could end up going to a jury because there's questions of fact here. What that specific intent was. If the specific intent was to impede, obstruct, or delay the administration of justice, then he could be found guilty. But again, based on all of the facts of this case, the media involved, the amount that it would cost to take this case to trial, they're going to have to relitigate the Karen Reed case. And I know that everybody, I'm sure, as this gets closer to trial, I'm sure that's something you're going to hear over and over and over and over again from the judge and from the lawyers and from the police involved is, we don't want to relitigate the Karen Reed case. It's impossible not to, at least to some extent, because it's the background of this case. So they're going to end up relitigating the Karen Reed case. And we saw how long it took last time and how much it cost last time. And they're basically going to have to relitigate that again. And then ultimately, the question the prosecutor is going to have is, anytime you're dealing with a jury nullification type situation, you have to ask yourself, is a prosecutor really going to, is a jury really going to convict him based on the evidence that they're going to hear? Sometimes juries look at this and they say, I'm not convicting him. I don't care. He was right. Maybe what he did was not technically legal, but I'm not convicting him, period. Go ahead. We're going to have a hung jury. And I think if they take this to trial, there's a good chance it's going to end up with a hung jury, because
You're going to hear about the Karen Reed case again.
Yeah. And then it's going to end up costing the millions again. And I don't know when the elections are for this particular DA, but any other DA that steps in, I don't know if he's going to get reelection. Okay,
I think it's next year for him, Morrissey.
There's a very good chance that this case won't even get there before the election. But especially now that there's 5,000 pages of discovery missing, that's going to take months to go through, and there's going to be more discovery based on that. But any other DA can come in if a new DA gets elected and say, I'm not taking this case. I want to dismiss this. I don't want to waste taxpayer money on this. I don't want to waste resources on this. They can come in and either offer Turtleboy a real sweetheart of a deal, or they could just say, this case is dismissed. We're done.
So in terms of the fact that they're saying in here that telling somebody to say the truth could be a form of witness intimidation, what would you think about a commissioner calling in a rookie cop who's told the FBI about things that she saw, which would implicate some high-ranking individuals that work in her office, and she's called in by the commissioner, who's telling her to do the right thing and tell the truth? I mean, is that not also witness intimidation?
It certainly could be. That could certainly form the basis of it. If there was a grand jury that was impaneled and given that evidence, there's a very good chance that they would indict. The likelihood of that happening, I think, is about the same likelihood that any people inside 34 Fairview get charged with murder by the same DA. I think it's 0 or very close to 0. And I just don't see it happening.
Well, I don't think
what she did and what they did absolutely could be considered witness intimidation based on the statute. You call in a rookie cop into the commissioner and into the upper brass and tell her, do the right thing. Do the right thing? Really? You're going to start telling rookie cops do the right thing in a high profile case like this, where there's all kinds of question marks about the investigation, video missing, questionable testimony that was given, probably perjury that was offered at different times. You're going to call in a rookie cop and say, do the right thing? How dare you? Now, if they have a policy to do that every single time a rookie cop gets called in, every single time they get subpoenaed, no matter what the case is, they call them in, they say, do the right thing, we're behind you, tell the truth. Okay, that's one thing. But that's not what happened here. That's not what happened here at all with Dever, however you say her name.
Well, I mean, it's okay because that whole memory also might be a false memory of Dever, because the commissioner says that it never happened. So,
Sure.
So maybe he doesn't want to get indicted on the witness intimidation charges.
Maybe.
Here's a question for you, Salman. Deidre Simmons. If Turtleboy's case is dismissed or settled, well, it can't be settled, could he ask for lawyers' fees to be paid by the Commonwealth?
Okay, the answer is yes. It almost never happens. I had this happen one time in a case where I had a case that I knew it was going to be a civil case. So I took the criminal case, and I didn't charge the guy for the criminal case. He was charged with some nonsense charges. And I took the case and got those charges dismissed and then sued the law enforcement agency involved. What happened in that particular case was, on the day of the trial of the criminal case, when I showed up, the judge was about to dismiss it. And I said, Your Honor, I do a lot of plaintiff's work. And if I show up day of trial and the prosecutor and the defense attorney is there, and the defense attorney is ready to go, and the defense attorney prepared for trial and had witnesses on standby and sent out subpoenas and is ready for trial and took time off of his schedule to prepare and be ready for trial, and then I show up and say, I'm not ready. You know what happened to me? I'd get sanctioned. I would have to pay his costs and fees. And I would certainly be ordered that if I want to bring the case again, because this is dismissed without prejudice, if I want to refile the case, I certainly have to pay his costs and fees. So why is it the prosecutors get special treatment? And the judge kind of looked at me and he smiled and he goes, you're right. And he ordered sanctions. And he said, if the prosecutor wants to refile the charges, they have to pay X amount. I forgot how much it was. And they appealed that, and they were not happy. They didn't win, but they were not happy about that. It's the only time I've ever seen that happen. Ordinarily, when you get to a case and they're willing to dismiss it, you're thrilled. And you just kind of leave it at that.
Yeah. And you know what's interesting about this case is I've done some research myself into some of the case law in Massachusetts that has to do with witness intimidation cases. And from everything that I've seen, it's always a defendant who is the one trying to intimidate witnesses. It's always the person who is in jail. Like, You find this happen all the time. In fact, I think there's some allegations of this in the YNW Melly case, if anyone's following that, where he was in jail, and then they're making some allegations that he was trying to, tell witnesses either yes to testify, not to testify, forget certain things. And that's like every single case that I've seen so far was like a defendant trying to convince somebody not to testify or change their testimony. You don't find where they're prosecuting some third party for alleged witness intimidation. Have you ever had cases of witness intimidation, Salman?
I have. Not very many. This is not something that's very common. The one that kind of comes to mind is I had a case where somebody was being charged with, I forgot exactly what the underlying charges were. It was serious. And I showed up for a pretrial thinking it was just a normal pretrial and we were going to pick dates and get discovery and then come back and try to resolve the case. Prosecutor made a verbal motion on the record to revoke his bond and have him taken into custody because the main witness against him had his tires slashed, his windows in his car broken, and his house set fire. And the judge's eyes popped out, looked at me, and he goes, well, Mr. Radner, I don't know if I can let your client out. And I said, well, Your Honor, in all fairness to my client, first of all, there's no proof that my client had anything to do with this. Second of all, this is a very bad neighborhood in Detroit. Bad things happen to good people all the time. And third of all, this could all be fixed and prevented with a tether. So the judge kind of called us up to sidebar. And he looked at me and he goes, you're joking, right? And I said, no. And more importantly, I wasn't given notice of this. So if you're going to lock him up, I want to have a bond hearing. I want to be able to subpoena witnesses. I want to know more about this. Right now, we have nothing but the prosecutor say so. So he looks at the prosecutor and he goes, are you good with the tether? The prosecutor kind of smiled and said, that's fine. So they put a tether on him and he continued to stay out. That's the closest I ever got to witness intimidation, other than the case I told you about that I witnessed when I was a very young lawyer. And I saw a witness, I saw a lawyer tell a victim that they should really be pleading the fifth, which I thought was a risky thing to do as a lawyer.
Yeah. Thank you, Idiot Wind, for becoming a new member. You got to love the names here.
Love the name. Maybe it's Wind.
Wind. Jen Goods, thoughts on Tully making fake grand jury summons?
Not familiar with what that's referring to.
Yeah, I'm not familiar. Is that in the letter? Did you notice that in the letters? Where Tully making fake grand jury? I'm not sure if I noticed that. I know that there's a lot of stuff that Turtleboy knows and talks about that may not be in the file.
Wait, hang on. Maybe that's referring to the 4,727 pages of relevant material from Lieutenant Tully's cell phone, in fact, contain more than 4,000 blank pages.
Okay, well, maybe it's one of those fake grand jury summons, but yeah, I mean, Turtleboy knows a lot more stuff that may not be in the file, so I don't want to, talk about stuff that may not be in the court file. Ant BB2, Commonwealth doesn't want the info within the text coming out. If they dismiss the case, does the public still have the right to review said text, or do they remain sealed? So, if, for example, if let's say a lot of the discovery they're sitting on now is text messages, and let's say all the stuff is still under an impoundment order, and then they say, you know what, forget it, we're just dropping the case. Does the public still have the right to see those text messages? And I would imagine that it has to do with that order of impoundment. As soon as if they don't turn it over, then okay, that's one thing. If they say we're not turning it over, forget it, we're dropping the case, well then, maybe you can't have access to it, right? But if this is stuff that already Turtleboy has and they're just under this order of protective order, then they have to start moving to remove that protective order, right?
It's up to the judge. This is something which, and again, this is very state by state. I don't know Massachusetts law, obviously, specifically. But this is something that varies state by state. Sometimes protective orders or impoundments will remain in effect after a case is dismissed. Usually it's not. Usually once a case is over, things like this will be released. But sometimes if it's something which is personal or something which would ordinarily be considered privileged, then it might not be subject to disclosure. But a case like this, I don't see how they could possibly keep it impounded after the case is over.
Yeah, I know that some people are working to get the sidebars unsealed in the Karen Reed case, as they're still sealed, and I know that a lot of people want to know what happens at that sidebars, and me included.
I'm curious about if they would appeal. Let's say the defense were to appeal the conviction of the drunk driving. Then would the transcripts and those sidebars be made a part of the appellate record, or
Well,
would
what
they be
happened?
under seal in the appellate record also? I'm curious
Exactly.
about that.
Yeah. I mean, it would be.
I don't know
it would
the
be-
answer. I don't know
No,
Massachusetts law.
Right. All right. Florida fan says, thanks as always for these informative chats, guys. Kristen from Manhattan, a big supporter of this channel. If there is a resolution to Turtleboy's case in the form of pleading to minor charges, how would this impact any potential civil action Turtleboy may have? What would your recommendation be if there's an impact to his civil claim? So go ahead, Salman.
Okay, so very often, if there's a false arrest or malicious prosecution case, the general rule often is if you're convicted of one, you can't sue for any. That's not always the case. There was actually a recent Supreme Court decision in which it was a very interesting split. It was 5-4 or 6-3 in favor of the plaintiff in that case. Shia Vareni or something versus City of Napoleon, Supreme Court case, in which it's actually interesting the way that the makeup of the court was. I remember that there were liberal justices and conservative justices that got together and actually said that this case could go forward, which I thought was very interesting. But basically, the answer is it does not necessarily mean that you can't file suit. It's very difficult. A case like Karen Reed, where she's convicted of drunk driving and she's charged with murder, I think it's going to be much easier to file that as a lawsuit because the two are not necessarily connected at all. The fact that you were driving drunk in no way means that that there's any evidence at all that you hit somebody or killed somebody or intended to murder somebody. And the fact that they continued to charge her with that, even though there was literally no evidence that she did, I think could subject them all to a malicious prosecution lawsuit under the Due Process Clause. There's other claims there as well, but we're asking about me specifically. We're asking about this type of claim specifically, so that's what I'm addressing. When it comes to Turtleboy, though, depending on what he pleads to, like let's say he pleads to one count of a misdemeanor. Okay, let's just say. At that point, I think it becomes very, very difficult to file a lawsuit because at that point, you're acknowledging that you were harassing, intimidating, threatening, in some way impeding with a witness. And once that's the case, then it's too similar to the other charges that are being dismissed. If you were being charged with witness intimidation and assault and battery of somebody somewhere else, or something carjacking, and then they go to trial on both, and he's found guilty only on the witness intimidation but not on carjacking, which has nothing to do with anything, then potentially he'd be able to proceed in a lawsuit against the carjacking case. But the way these claims are, and the way these allegations are, and the way the charges are, I don't think he'd be able to file suit. But again, it's very fact specific, and it's possible that if they're trying to conflate things that happen to different so-called victims, it's possible that he will be able to sue. But I would think just from 20,000 feet, I doubt it.
Okay, and so just to come back to the Karen Reed case, because I know a lot of people are wondering about the fact that she was convicted on plain OUI. Is that going to impede her ability to be able to file a civil rights 1983 lawsuit? And it seems what you're saying is that she still would be able to pursue that because it's so drastically different than a second-degree murder charge.
Right.
Okay.
It's so drastically different. And the ultimate question is whether there was probable cause or a reasonable basis for them to charge her with murder. If they were acting in good faith, that's an absolute defense. I don't think they were acting in good faith. I think that there's ample evidence for her to sue multiple people on that case. We could do a whole video about this, about the various people that she can sue, but at the very least, I think she can sue the prosecutor's office, not individual prosecutors, because they have their immunity is too strong, which I think is absolutely shameless and outrageous. Just to give everybody, an idea of how this works, even if you prove that a prosecutor, and I'm not saying this happened here, but even if you prove that a prosecutor put somebody up with the intent to commit perjury, if you uncover an email from a prosecutor to a so-called victim saying, I want you to say this, I know it's not true, we're going to prosecute this guy, we're going to put him in prison, and we know he's innocent, you still can't sue that prosecutor. The only thing you could possibly do is sue the prosecutor's office under what's called a Monell claim, M-O-N-E-L-L. That's where you are able to establish, and it's virtually impossible to do this, that the prosecutor's office has a policy, procedure, protocol, or custom to violate people's rights. It's virtually impossible to do. You could sue the police for this, though, and that's usually what people do. And that's what I think. I think she would do that, and I think she should do that. And frankly, I think she will do it. And it's just a question of when and what exactly the allegations will be and who all the defendants are. Because another thing is you can actually sue non-government actors as co-conspirators under a 1983 claim, which is usually only to sue government actors. There's a lot here, a lot to unpack here.
Well, speaking about policies and procedures, Adam Lally, actually, the prosecutor in the first case and the second chair prosecutor in the second case, actually just took the stand in a different case, a Miles King case. And they had an evidentiary hearing where he was talking about it. He was asked questions about the prosecutor's policies, procedures about turning over Rule 14 discovery and Brady material and what his process is. And he said there is no policies or procedures in the DA's office. They just expect everyone to know Rule 14 and follow it. And then he talked about something that I found really interesting is that he talked about a list that he has, some sort of list of all the documents or discovery that's requested that has to be turned over. And when he goes through the list and he sees that certain things are not turned over, he makes an inquiry about them. And he asked Trooper Proctor about it, whoever is involved. I was very interested about that list. Like, what type of list is this? Is this on a yellow pad? Do you have a yellow pad for each case? Do you it was just, you have to see it, Salman, to believe it. But this was something that I did a little bit of a analysis on because it was somehow related to the same players in the Karen Reed case. Here's a comment for you, Salman. I think Turtleboy should add attorney Salman Rander to his defense team or a civil case where he's suing people for defamation. Well, Salman,
Turtleboy has exceptional legal representation. Mark Betterow is an exceptionally good lawyer. He's got a great legal team. They don't need me. If they needed me, they know how to reach me. They don't need me. I'll leave it at that.
Alyssa says Lindsay was served with a subpoena for the grand jury that was completed days before it was served. That's what made her a witness. It's in one of the first Betterow letters. Okay, so I got to go look over the first Betterow letters.
Okay, that's certainly an interesting point. I mean, obviously, you have to know that the person's a witness. That's part of the specific intent. So I'm not sure exactly what that's referring to, but if Mr. Carney didn't know that Lindsay was a witness or was subpoenaed to be a witness, then I don't see how you could possibly be charged with intimidating her as a witness.
Yeah, no, I think they're talking about the fake grand jury summons or something that was for Lindsay, who was his old girlfriend or something. Whatever. It's a different issue, but we don't have time probably to get into it. But here's another comment from Idiot Wind. Would records of these alleged victims being the aggressors towards Turtleboy, which may solidly establish that Turtleboy did not cause them trepidation or intimidation, maybe, go to whether this constitutes witness intimidation? Also, name is a Bob Dylan song.
Okay, very good. Good old Bob Dylan. Okay, the answer to your question is absolutely that would be relevant and absolutely would be discoverable. Again, I don't know exactly how it works in Massachusetts. I know that if this were in Michigan, I'd issue a subpoena directly to them. And I have done this in cases. If there's a so-called victim making allegations against somebody, I will subpoena their phone records. I'll subpoena their emails. I'll subpoena them directly. I'll make it very clear we are going to uncover the truth here. And if there's text messages between you and somebody else saying, let's screw this guy over, then that's going to come out. That's going to be exhibit number one that I show the jury. Now, usually what they do is they're smarter than that and they delete their messages. But I have had cases where I catch them off guard and I say, you have your cell phone on you? Why don't you take it out and tell us what messages you have with the so-called victim in this case? And usually the prosecutor will object, but if they have their phone on them, the judge will say, well, do you have your phone on you? Take it out. Let's see. What's the objection? Well, let's see it. She's here. Let's look at her phone.
Yeah, so some of this is that Turtleboy makes this also like that Brian Albert, this real tough cop, is going to be intimidated by him. Correct. You know, like, really? You know, you're intimidated by a journalist, or even if there's a few people shouting outside your home, you're going to get intimidated by that. Like,
I don't know if you have to prove intimidation.
Well, you have to prove intent, right? That he intended. Now, so that's,
I'm going to pull it up right now. Hang on. The elements of witness intimidation.
So
the defendant threatened, intimidated, harassed, misled, or caused physical, emotional, or economic injury to another person. I think that means subjective to the so-called victim. There obviously has to be an objective component also, that there has to be that specific intent. right? Or I guess they're both subjective, but it
Right.
would be that the criminal, so to speak, the suspect, acted with this specific intent to intimidate and harass. But I think based on these elements, the victim also has to feel threatened or intimidated, and if that's not the case, then it doesn't work. I remember there was a case I worked on where somebody had a gun pointed at his head, and his testimony at trial was he didn't feel scared, he didn't feel threatened, he felt completely calm. And everybody in the court, especially the prosecutor, looked at him like, "You didn't feel anything?" He goes, "No, I completely believe in God, and we just left our Bible study, and I was completely resigned that whatever happens, happens." And the prosecutor's like, "You didn't feel," and then she started reading the actual statute, like each word from the statute. No, didn't feel any of that.
Right. So
It was pretty cool testimony. But I'll tell you what it did. It proved without question that everything else he was saying was true, including the fact that my client pointed a gun at his head.
Right. So
overall, it definitely helped the prosecutor, not hurt.
What the witness intimidation comes down to in Turtleboy's case is that you got all these witnesses, like Brian Albert, Colin Albert, Chris Albert, and to call a spade, he was being annoying. You can chalk that up to harassment, but harassment's not a crime. Witness intimidation is a crime. Harassment's not.
I think there's a question of fact as to whether he committed some of these crimes. I think that there's enough, at least for some of them, to get to a jury. Right. Whether a jury will convict him, I don't know. I got to tell you, I think with a case like this, the likelihood of a conviction, I think, is pretty low. I think that there's a strong likelihood of a hung jury. There's also a decent likelihood of conviction, at least on some of the charges. But I think the likelihood of an absolute conviction, I think it's relatively low as these cases go. Certainly low enough that the prosecutor should want to resolve this with, look, the prosecutor at this point is already, like, what pride do they have left? What ego do they have left? And again, that's not supposed to be the thing that drives this. It's supposed to be the pursuit of justice. But the fact of the matter is, I would think that the prosecutor at this point would just want this case to be over. What are you doing at this point? You're humiliating yourself. You're humiliating your office. You're humiliating these officers. Look at what's happening now in all these other cases that these cops were involved in. There's going to be motions filed in every single one of these cases, and convictions, by the way. Anytime anybody who's been convicted based on the testimony of Buchanan or Deaver or Proctor or any of these guys, there's going to be motions filed now to set aside those convictions and to reopen the case.
Yeah. So just
if I were the prosecutor, I would want this to be done and over with. I mean, I'd probably offer him a parking ticket. Just make this case go away, please.
Right. And just something that the opinion in the judge, and this was the motion to dismiss, where he denied it. I mean, he did grant some of the parts, but like Michael Proctor is not a I guess a victim in the Turtleboy case, and also Buchanan's not considered a victim. So but what the judge did lay out is that all these people did testify in the grand jury that they felt intimidated, and they felt like Turtleboy wanted them to change their testimony or not testify. So Jennifer McCabe said that, and Brian Albert said that, and Chris Albert and Colin Albert. So they got their statements, but it doesn't really only come down to that. The big question that you and I both know here is, how can they prove intent? How can they prove that he intended not just to be annoying and in their face and stand up for what he thinks is truth, and actually he wanted to and intended on intimidating in such a fashion that they should not testify, or that they should change the testimony.
Okay.
And let me just finish up the thought. And then what the judge basically says in this opinion is that, well, if you take the entire context, even though you can't point to one specific statement that he said, something like, you better change your testimony, or you better not testify, or something like that, where it's not direct evidence like that, a lot of it's circumstantial, which does happen, occasionally in witness intimidation violations or charges. But what you have here is that he's saying, well, with all the context of everything that's going on and all his YouTube shows and everything that he spews and all of his activism and rallies and bullhorns and all that, a jury can read into that what he intended on doing was intimidating witnesses. And that's kind of like how the judge leaves it, as this is why it goes to the jury. So again, I don't feel...
Okay, let's unpack that in two ways. First of all, there's also the reckless disregard component. Okay, it's not just necessarily that specific intent. There's also the reckless disregard for whether that will happen. Okay, so that's
an
obviously
important part. Yeah,
right. Definitely a very important part. I think probably an extremely important part.
Yeah, no, that's true. So, it was this all reckless disregard. His tone, his demeanor, all of his YouTube shows, everything that
Right.
he's.
Well, okay. The other side of this is, there were a lot of people in the news that were talking about this case. Some of them were talking very aggressively about some of the witnesses. Is that witness intimidation?
Mm-hmm.
We're getting very close to First Amendment issues potentially. And I think that that's something that, again, the prosecutor is not going to want to take this case up to the Supreme Court, the United States Supreme Court, on the First Amendment issue. Okay, Mr. Carney probably would. If he actually goes to trial on this and is convicted, I could see him appealing this all the way up. And this case, particularly a case with this much media interest, what's stopping the prosecutor from charging Court TV or NBC Boston or you or me or anybody else getting up on the internet, getting up on YouTube, getting up in the news and saying this person's a liar, why are they doing this? This person should be ashamed of himself. Hey, wait a second. That's reckless disregard for whether he or she will see that on TV and be intimidated from testifying. Well, now we're really straddling the First Amendment in a very scary way. So is that likely to occur? No, I think it's really not strongly likely to occur. I think the prosecutor would be crazy for trying to do something like that. But the question then is, where's that line between what Turtleboy did and what Court TV did or NBC News or any other media outlet?
Which is probably why all the cases that I've seen was when a defendant is trying to intimidate a witness.
It's more than that. Mr. Turtleboy certainly could be viewed as part of the media. So from his perspective, and I think from a jury's perspective, and from ultimately possibly from the Supreme Court's perspective, what's the difference between him and NBC News or Court TV? And if there isn't that much of a difference, then you got to look at, okay, well, what if NBC News would do this? And let's try to progress along to the next logical step, which is, okay, well, what else did people say about these witnesses? There were plenty of people saying very negative things about a lot of people in the case. What if Karen Reed would have testified? You know how many people would have been on the news vilifying her and saying horrible things about her? Could all those people tweeting and talking on the news, and you showed me a clip of some guy here in Detroit blasting Karen Reed. I don't even know. I don't know who the guy is. I don't know what he was saying. All he really talked about was how much he hates Karen Reed. I think it was a Court TV clip. What if she would have wanted to testify and because of him, she didn't? Can he be charged now with witness intimidation? Because he acted with reckless disregard as to whether she would feel emotionally charged enough to not want to testify. I mean, we're getting really, really close to First Amendment issues here. And I think that's one of the reasons the prosecutor, if they were able to think this through rationally and logically and not emotionally, they would want this case to go away.
Yeah. Well, that's a good note to end it, but I do want to read this last note here, the super chat from Tara Rayner. I'm late to the show. Hi from, I'm not sure if that's Canada or California.
I'm heading to Canada in about an hour. Well, less than an hour. So that's actually why we got to wrap this show up.
The discovery where Trooper Tully's texts to prove is part of the whole setup. Norfolk has a serious corruption issue. Okay, so that was part of the discovery requests where Trooper Tully's texts, I guess, with Kate Peter. And maybe that's what they're going after. So here, another just here, two truth for liberty, line drawing for criminal laws must be in favor of the defendant.
100%.
Amendment, and that adds
1,000%
to the injustice of this prosecution of Dr. Turtleboy. Yeah, which is why I think what you're saying, Salman, is that the best way forward for everybody is to get some sort of slap on the wrist here.
This case resolved,
And
especially the prosecutor. Especially the prosecutor. You don't want to be the prosecutor who erodes the First Amendment any more than it's already been eroded.
Yeah.
You've got somebody in the media who was not involved in the case, whether he crossed the line or not, and whether you actually want to litigate this case. Do you really want to be the prosecutor who creates, who erodes the First Amendment? I really think the prosecutor should think long and hard about this, and should very seriously considering either dismissing this case or offering just too good of a deal to pass up, whatever that might look like. And I don't know if Mr. Carney would take a deal. It could be he feels confident enough and strong enough that he'll just say, you know what? No, I don't care. Now, I look, just based on my experience, I don't know Mr. Carney. Okay, I really don't. What I can tell you is based on my experience with the hundreds of criminal cases I've worked on, is almost every single one of them eventually there's an offer that they would take. Whether that offer is made is a question and ultimately leads to trial. But I don't think I've ever had a criminal. There's one criminal defendant I had who told me from day one, I will not plead to anything, period. And we went to trial and got him mistrial after the second day. And then he sued the company that framed him and made a lot of money. But ordinarily, there's an offer somewhere along the lines if somebody's charged with murder and they'll reduce the charge to a parking ticket. I mean, Karen Reed would have taken that deal. Here, we'll reduce the murder charge to double parking, $100 fine. Of course, you would take that. You'd be crazy not to. So everybody has a deal that they will take. The question is, will it be offered? And I really think that the prosecutor should figure it out. They should get together with the defense attorneys, and they should figure out a resolution, get this case done. Because the First Amendment issues in and of themselves scare me too much for this case to continue to be litigated.
Yeah, that's a good point. Look at this from Penny Woods Law and Crime. Just wanted to check in with support for two fabulous counsel. I'm a 30-plus trial lawyer, and I'm still learning from y'all. Thanks again.
Wow.
I think personally that we probably have the most lawyers and people working in the legal profession tuning into our channel over everybody else. That's personally my thought on it. Now we have a lot of other people also, but because we actually talk about law and research and laws, like things like that. So all right, so Salman, I know you got to run. Thank you so much for giving us an extra 10 minutes today, and have a safe trip to Canada. We'll get you here, I guess, maybe a week and a half, 2 weeks, something like that.
Sounds good. I always love being here. Have a great Sunday, everybody.
Okay, thank you. All right, so that's Salman weighing in on the Turtleboy case, and there you have it. So again, always some great insight there about the First Amendment, and really that's what a lot of this case is. It's encroaching on the First Amendment, and it's an important amendment. After all, it's the first one. So when you start messing with the First Amendment, that's when you got to really take a step back and think whether you're actually pursuing justice or the opposite. So when it comes to Turtleboy's case, even though you may be able to technically argue to a jury why he should be convicted about one or two of the other things that he did or said, but that's not really how probably you want to go down in history as that prosecutor trying to take away the First Amendment, and then that would lead down who knows what the road that will lead down, as Salman laid out for us. So that's Solomon's take, and it was a great conversation. So thank you very much, all of you, for joining us today on the Sunday show. Next Sunday, unfortunately, we will not be having the show, but we definitely we're going to get Salman back on a number of different issues, I'm sure, as they arise. So there's a lot of work that we still have to do on some of the other cases. I know the Brian Walsh decision just did come down. I got to read it and analyze it and make sure everybody understands what the decision is all about. So that's going to be on my plate this week. I know there's some motions that were filed in Donna Adelson's case. We're going to have a hearing coming up. And also the follow-up to the federal materials on the Brian Walsh case. That's going to be up for status hearing, I think, this Friday, August 1st. I think that's when it is. So there's definitely plenty of work that we have to get to. I think somebody made a mention about the closing arguments in the trial that's going on right now. Maybe that's going to be tomorrow. Maybe we'll do something like that. Maybe we'll just stream that. So we got to figure this all out. But thank you all for joining us today. Appreciate all of it and all of you. And like always, we're going to see you next time. Have a great rest of your Sunday.